The Institute
for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your weekly podcast on the Federal Courts of Appeal. I'm your host, John Ross. Today I'm joined by the all-star team, Clark Neely and Evan Bernick of the Institute for Justice's Center for Judicial Engagement. Clark and Evan recently released an annual report on the topic of judicial engagement and abdication in the nation's courts. You can read the report, entitled Enforcing the Constitution, at ij.org/CJE. This week on the show, the NYPD's not-so-secret surveillance of Muslim Americans, specious reasoning in a civil forfeiture case, and a panel tells the EPA to slow its roll on the new Clean Water Rule. Clark, kick us off.
First case comes up out of the Third Circuit and involves a lawsuit that was brought by a number of Muslim groups against the New York City Police Department, asserting that it had essentially adopted in the wake of the 9/11 attacks an illegal and widespread surveillance program of Muslims in the United States. And the question that went up to the Third Circuit was whether the plaintiffs in the case have standing to bring those claims to challenge the program on its face as discriminatory, and second, whether they stated a claim under the Equal Protection Clause of the 14th Amendment and the Free Exercise and Establishment Clauses of the First Amendment. The district court threw their case out rather unceremoniously. They appealed that decision to the Third Circuit, and we got the Third Circuit's decision last week.
The fundamental question that this case presents is whether the government in any context has essentially arbitrary, unchecked power to single people out and treat them disfavorably without citing any specific evidence related to criminality at all whatsoever. And this fundamental question is something that's been worked out in the courts over the course of the last few decades, and the court's records haven't always been very good.
Well, John, if I could, it's important for people to understand two things. You pointed out one thing in the introduction, and that is that this program is increasingly not secret. It is increasingly clear to people that there is a surveillance program, so it's not particularly secret. So one wonders, what interest the government has in maintaining the secrecy about its existence. The other thing to understand is that it's not merely a surveillance program, although the surveillance that's alleged is pretty disturbing in terms of taking pictures of people going into mosques, having cameras pointed at mosques and cars coming and going and so forth. But we're talking about the police actually infiltrating Muslim groups. So, for example, there's an allegation that an undercover NYPD officer infiltrated himself into a Muslim student organization's rafting trip and observed and made notes of the number of times the students prayed while they were on the trip, et cetera. This is really at the level of a kind of secret police state that we saw, for example, in Behind the Iron Curtain. And the question is, very live question, is it justified by our legitimate security needs? But it's important for people to understand just how intrusive this program appears to be.
Yeah, it really is appalling. The allegations are very specific. There's extensive documentation, and the district court actually punted on the question of whether to rule on the case at all. So they found that the plaintiffs didn't have standing. They hadn't alleged facts that were specific enough to even get them in the courthouse door. The Third Circuit rejected that approach, and properly so.
Why did they reject it, Clark?
Well, what they rejected was the idea that the government, because it's a national security issue, or at least allegedly a national security issue, that the government has essentially unfettered, unreviewable authority to conduct any program it wants at any level of intrusiveness, and it's none of the court's business, no matter what the government does. It's important to understand that that's all that this initial case is about, because it's not going up on the merits. It's simply going up on the question of whether the organizations and individuals who claim they have been targeted for discriminatory and illegal surveillance have legal standing to challenge the program in court. That's all that we're talking about at this stage of the case.
Now, the Third Circuit brought up some historical analogies, Evan.
Yes, and the backdrop of this case, and really the court brings it into the foreground, is the federal judiciary, and in particular the Supreme Court's record in national security cases, particularly in contexts where, because there's a war, because there's a perceived threat, the government wants to do something. The most infamous example of this is, of course, the case of Korematsu v. United States. This involved an internment program set up by the Roosevelt administration for people of Japanese ancestry based on speculation about the threat of Japanese invasion, Japanese spies on the West Coast. The government lawyers who litigated that case essentially lied to the Supreme Court. They made representations that we now know weren't true, and more than that, were known to be untrue at the time. And the Supreme Court ratified that program.
And just to be a little more precise, let's give credit to the lawyers who were the frontline lawyers arguing the Korematsu case. Once it became clear that the government's initial position in that case was no longer supported, basically they had litigated the case in lower courts on the basis of one report that said that Japanese Americans might be a genuine security threat. But then another report came from the War Department saying, nope, that's just not correct. What happened basically was that the line attorneys at the Department of Justice said we need to advise the Supreme Court about this new report. They were overruled by senior members of the Justice Department. That second report was suppressed, and the Korematsu decision was made on the basis of intentional deceit by the federal government. We know that in part because the Solicitor General's office later, much later, did something what they call a confession of error, which is a very elegant way of saying, whoops, we dissembled, we deceived the court, and got a ruling upholding our program partly on the basis of false representations.
And Korematsu is still good law, Evan.
Korematsu is still on the books, and this decision is a repudiation of the basic reasoning that underlied Korematsu. The idea that in the name of national security, the government has effectively unchecked arbitrary power and the court should essentially step out of the way. In this case, the court applied the heightened scrutiny that it applies in cases that don't involve national security on the basis of suspect classifications. It engages, and these people get in the courthouse door.
It bears mentioning that there's a wonderful blog post by a former Short Circuit guest, Professor Steve Laddick over at American University. He has a blog post this morning on the Just Security blog in which he elaborates the point that Evan just made, which is that in his view, the Third Circuit's decision amounts to a repudiation of the Korematsu case. In basically, there are two primary failings of Korematsu, as Professor Laddick sees it. First, there's what Evan and I just discussed, which is that the policy of interning Japanese Americans was unnecessary from the start. It was not really important or necessary to national security. But second, there was the judicial rationalization of this horrendous discrimination against and unjustified discrimination against a whole ethnic group. Fast forward to today and just substitute a religious group for an ethnic group. We have to ask ourselves, is that the kind of country that we are, where we allow our law enforcement and we allow our national security officials to target innocent people simply because they're a member of a particular group? I think for most people, that's not the country they think we live in. And the most important, I think, takeaway from this case is that the NYPD should have to answer for its actions. They should have to at least explain more or less what they're up to. Of course, they may have some legitimate security things that they can keep secret. But generally speaking, people are entitled to know what this program is about and whether it is in fact targeting people who are innocent of any, or at least for whom there's no specific evidence they've done anything wrong, just because they are Muslims.
Right. I mean, when the government behaves abusively, it's appalling enough. But it's still yet another thing more horrific when the judiciary turns around and rubber stamps that or endorses it and says, that's fine, that's consistent with the rule of law. That, in the long term, is even more destructive to the rule of law and to our constitutional fabric than individual government abuses in a particular case.
Okay, let's move on to the next case, which comes out of the Sixth Circuit. Clark?
So this case involves the Environmental Protection Agency's promulgation of a new rule, the Clean Water Rule, that attempts to bring some clarity to the question of what constitutes a navigable water under the jurisdiction of that agency and ultimately of the United States government. This is an issue that has been utterly perplexing people who, from the property owners who have to abide by whatever the rule is, to the courts, which have tried to interpret the Clean Water Act to understand exactly what constitutes a navigable waterway. And what happened here is that a number of states got together and challenged the promulgation of the new rule on a number of grounds, including that it violates the statute, that basically the rule departs from the statutory language in some significant way. Second, that it was promulgated in violation of rulemaking procedures, basically didn't conform with notice and comment. And then from a policy level, it just radically alters the traditional state-federal balance over protecting the environment, including waterways, and basically just creates a huge change in how states, how much control they have over their own waterways. So, procedurally, the question was basically whether at this point the Sixth Circuit should step in and stay the enforcement of the new rule pending the outcome of the case.
And what did the Sixth Circuit decide, Evan?
The Sixth Circuit decided to stay enforcement of the rule. They found compelling reason to think that the petitioners would succeed on the merits. There are aspects in which both the rule was made and with respect to the substance of the rule itself that are problematic, and therefore this case is going to go forward.
Clark, you said the rule dramatically expands the EPA's authority. What did you mean by that?
Well, up until this point, there's sort of been a division of authority over navigable waters, or indeed all waters, between state and federal government. This rule vastly expands the role of the federal government in regulating those areas to the detriment or to the derogation of state power. And the Sixth Circuit correctly, I think, holds that before such a sweeping rule is put into effect, there should be an opportunity to determine whether it is in fact valid. The Sixth Circuit ends its opinion with kind of a pun. It says, the sheer breadth of the ripple effects caused by the rule's definitional changes counsel strongly in favor of maintaining the status quo for the time being. The ripple effects in a clean water case. Rimshot. Now,
is this an example of engagement, Evan?
Well, it's an example of engagement at the threshold level as to, it's not an adjudication on the merits. We don't know whether the rule is valid or invalid, but the court does things that we associate with engagement. It focuses on the lack of specific scientific support for the distance limitations that were included in the final rule that the agency offered, and distinguishes that from the initial rule that was proposed and says, hey, you need to provide a reasoned explanation every step of the way.
And they also noted that there appears to be a lack of scientific support in the administrative record for at least some of the provisions of the new rule, and that would be consistent with engagement as well. If the government's going to assert as true a particular fact, and yet there is no scientific support for that fact, then that should be problematic. I mean, the whole point of having a notice and comment and part of the rulemaking process is to make sure that the agency has considered the facts and is not simply attempting to promulgate some preconceived idea of what would be good policy.
Right. And even if that final rule were an example of good policy, you need to provide notice to the affected parties so that that there can be a give and take about the content of that rule. They can object if necessary. It's not enough just to get to the right result. You need to provide a reasoned explanation for what you are doing. And that's what the court insists upon.
Okay, let's move on to the last case, which comes out of the Ninth Circuit. Evan?
Well, this is really an outrageous case with a happy ending. It arose from a conceitedly unconstitutional warrantless search of somebody's property on the basis of the belief that he possessed drugs. There was a search. They seized thousands of dollars worth of his money, and there was then a forfeiture proceeding, an effort to forfeit that money to the government. And the district court looked at this and they said, look, this is clearly unconstitutional conduct. You all should be ashamed of yourselves. But when it came to allocating the money to the attorney who represented the victim of this forfeiture, the district court said, you don't get all that you're asking for because the government was making meritless arguments and you took them too seriously.
Clark, could you expound on that a little bit more?
Yeah, I mean, basically the district court does something that district courts frequently do in determining the amount of attorney's fees when there's a statutory provision for attorney's fees, and that is to find any way they can to diminish the amount that the prevailing attorney will get. In this case, the district court did that in three ways. First, by disregarding evidence that the prevailing attorney submitted as to a reasonable hourly rate for this kind of forfeiture work. Second, by diminishing the amount of basically by reducing the number of hours for, as Evan pointed out, basically taking too much time to respond to the government's quote-unquote specious arguments that apparently the attorney just sort of understood that the judge would get that they were specious and not spend so much time briefing them. And then third, reducing the hours even further, just simply across the board, just because, you spent too much time, but without documenting any particular ways in which the time is excessive.
So let me make sure I got that right. The government made bad arguments, and the lawyer spent time preparing to combat those arguments, and the district court said you should have known ahead of time that these were specious arguments and not prepared so much?
Yes, that's exactly what happened. I mean, the opinion reads like a comedy of errors. They ignored estimates of reasonable fees that were provided by six forfeiture attorneys who have experience in the area. They, as you pointed out, essentially blamed the lawyer for taking the government's arguments too seriously, when in fact the government took them seriously enough to make them. And more broadly, this issue of fees is particularly pressing in the forfeiture context. Forfeiture cases can go on for years. They're very complex. They're very very time intensive. And if compensation isn't available for lawyers, lawyers, you will have victims who are unable to get the justice they deserve in the court at the end of the day because people will be unwilling to represent them.
Evan said there was a happy ending, Clark.
Yeah, there is. The happy ending is an engaged appellate court that basically applies the law as it is written. Namely, you can only diminish a sufficiently supported fee petition for specific, articulable, demonstrable reasons. It's really important, I think, to unpack exactly what happened here because it's so shocking and it really underscores the need for judicial engagement in all settings. What happened here basically is a court on the merits, the court said, look, you shouldn't have spent so much time responding to certain of the government's arguments because they were so clearly specious, but then embraces a clearly specious rationale for diminishing the amount of the fee award itself, leaving the attorney to wonder which specious arguments should I spend time responding to and which should I not, because the judge completely blew it on the law when it comes to the fee petition. Imagine if this lawyer had been less diligent in briefing those issues. Could the district court have missed it by much further? Probably not. But thank goodness he was diligent in the Court of Appeals to responding to the district court's equally specious rationale for reducing his fee award. The bottom line, there is no argument so specious that an attorney can take for granted that the judge is going to get it right. So attorneys should be diligent in all cases to make sure they make the best legal argument that they can, and judges should be engaged in all cases to recognize that even specious arguments can sneak through, just like they did in this case, up until the Ninth Circuit got involved and reversed the district court. That's the happy ending. The attorney in this case gets the full amount to which he's entitled.
Okay, that concludes the show. Thanks for listening. I hope you've enjoyed our time together today. I know we have. For more judicial engagement, be sure to follow Clark and Evan on Twitter. Their handles are @ConlawWarrior and @EvanBurnick. Until next time, this is John Ross from the Institute for Justice, badgering you to get engaged.